This case opens quietly, but don't let that fool you. What you're about to watch is a courtroom collision between mental health claims, public safety, and judicial patience wearing thin. We're looking at People versus Barrage Scott, a hearing that starts as a routine competency review and quickly escalates into a tense bond decision with serious consequences. The court has already reviewed a psychiatric report and ruled Scott competent to stand trial, meaning he understands what's happening and can assist in his defense. But here's the twist. Competency doesn't equal safety, and it doesn't guarantee release. As you'll see, Scott's defense leans heavily on family support, medication compliance, and mental health treatment as reasons for leniency. On the other side, the prosecution and judge are weighing something very different: history, risk, and what happened the last time the court took a chance on him. Keep your eyes on how the judge responds when past behavior collides with present promises. And ask yourself as you watch, how many chances is too many when public safety is on the line?
Competent, Your Honor.
Yes.
Who stipulates that, Your Honor?
And the people?
But also stipulate the defendant's comment.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life.
This moment right here is critical, and a lot of viewers misunderstand it. When the judge rules that Mr. Scott is competent to stand trial, that does not mean the court is saying he's mentally healthy, stable, or innocent. It simply means the legal standard is met. He understands the charges, the courtroom process, and can rationally work with his attorney. That's a low but very specific bar. Notice how quickly the hearing moves forward after that finding. There's no celebration, no relief, because competency actually moves the case forward. It doesn't slow it down. And while the defense immediately pivots to bond and mental health court options, the judge is already signaling caution. This is where strategy matters. The defense is trying to frame treatment as prevention, while the court is focused on patterns of behavior. So here's the question for you. Should mental health struggles weigh more heavily than past failures when deciding pretrial release?
He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, but he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the I think it was in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits.
This is where the tone of the courtroom shifts, and you can hear it. The judge isn't just denying bond, he's explaining why trust has been broken. He points out something judges rarely forget. He already took a chance. Mr. Scott was released before, and within a week, he was arrested again, this time involving allegations of pointing a gun at someone. That detail alone reframes everything you've heard up to this point. Family support, medication, promises of compliance, all of that starts to collapse under one brutal fact. Recent behavior: judges aren't required to gamble on hope when the risk is violence. And when the judge says, "I'm not going to take that chance again," that's not anger, that's risk management. So pause here and think. If someone keeps proving they can't stay out of trouble, does the system owe them another opportunity? Or does it owe the public
the
protection?
correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I got to go see Slay today. They said if I do get released, they're going to follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. You know, I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done.
This hearing ends exactly where the judge believes it must, with bond denied and custody continued. The court acknowledges mental health issues, recognizes family support, and hears emotional pleas about loss and responsibility. But none of that outweighs the central concern: public safety and repeated failure under court supervision. Competent or not, medicated or not. The court concludes that release is simply too risky, given the facts and history presented. This case highlights a harsh reality of the justice system. Compassion has limits when prior chances result in escalation, and mental health considerations, while important, don't override credible danger to others. Now we want to hear from you. Did the judge make the right call? Or should treatment and supervision have been prioritized over detention? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.